Welcome to the deep dive. Today, we're tackling a really complex area, coercive care.
Yeah, it's definitely got a lot of layers.
We're specifically looking at how it affects individuals with disabilities and mental health conditions.
Hmm.
We've got quite a bit of material here, excerpts from academic books looking at the laws, the rights, the policies around it all. Our
Hmm.
goal really is to pull out the crucial insights, get a clear picture of what's, important.
Exactly. Think of this as your way to get a handle on the key things to consider around coercive care fast. We'll be focusing on what you need to know about, well, the interplay between human rights and those often very difficult decisions involved in providing care.
Right. We know you're keen to get a solid understanding without getting bogged down in sort of academic jargon, so we're here to guide you through it.
Let's break it down.
Okay, so let's start with the basics. What exactly is coercive care in this context?
Well, traditionally, the whole idea of coercion in care has been really closely tied to mental health services, psychiatry mostly, and it's a topic with a lot of debate around it.
I bet.
And while we often think of coercion as, direct, forceful actions, it's actually broader, much broader.
How so?
It's about using power, fundamentally, to make someone comply. And this can include not just like active interventions, but also withholding things someone needs.
Like denying someone suitable housing or maybe educational opportunities or even just, social support. Is that the kind of thing?
Precisely, exactly that. And here's where it gets ethically, well, really tricky.
Okay.
These coercive actions, or inactions sometimes, are frequently presented or maybe justified as being in the person's best interest, as a form of care.
Right. The justification is care.
Yes. And this forces us, really, to examine what care actually means when someone is detained or, has very limited freedom.
Yeah.
It makes us think hard about the ethics of providing care when liberty is restricted.
So for people working in these systems, care managers, support workers, it must create some serious internal conflict sometimes.
Oh, absolutely. Our sources point out that care managers in New Zealand, for instance, dealing with their Intellectual Disability Compulsory Care and Rehabilitation Act from 2003, they really experienced this tension, this pull between providing support that seemed necessary and respecting the person's individual autonomy.
Okay. Let's maybe move on to human rights. It seems like there's a growing emphasis maybe on informed consent as a way to reduce coercion.
That's a really key development, yeah. International human rights laws are increasingly highlighting the importance of making sure people give their informed consent to care and treatment.
Okay.
So, for example, you've got Article 12, Section 1 of the International Covenant on Economic, Social, and Cultural Rights. That's a major international treaty. It guarantees everyone the right to the highest possible level of health.
Right.
And the UN committee that oversees this has explicitly said this includes the right to make informed choices about your health.
And the UN Committee on the Rights of Persons with Disabilities, they've gone even further, haven't they? Specifically saying all healthcare, including mental health care, should be based on informed consent.
That's it. And what's really crucial to understand here is that the aim, the principle, is for this to apply to everyone without discrimination.
Okay.
The challenge, of course, comes when we think about individuals who might be seen as not having the capacity to make decisions for themselves.
Right. That's the difficult part.
It is.
Good.
But the fundamental human rights idea is that the right to make informed choices shouldn't just be taken away because someone is perceived to lack capacity. It's meant to be universal.
This makes me think about some, older legal ideas. I seem to remember reading about Article 5, Section 1E of the European Convention on Human Rights.
Yes, that's a good point. That article does allow for the detention of people considered to be of unsound mind, and also individuals with alcohol or drug dependencies and vagrants. It definitely reflects a view from, say, the mid-20th century that these groups could legitimately be subject to compulsory treatment. But that perspective is much more contested now.
Why is that?
Well, mainly because of the risk of this power being used unfairly or without proper justification. The whole discussion around unsound mind has largely shifted now to focus more on the idea of capacity when we talk about limiting someone's human rights for health reasons.
Okay, capacity is the key term now. Got it. Now, here's something really interesting from our sources. Nicholas Rose talks about a politics of life itself related to health technologies. Can you sort of unpack that for us?
Yeah, Rose's idea is basically that we increasingly have the technological means to manage and control really fundamental aspects of human life. biology, health, etc.
Okay.
And he links this to governments getting more involved in the health of populations, particularly those populations seen as not being able to uh, manage their own health effectively. Not self-governing in health matters, as he puts it. Now, Thomas Buller adds a really important caution here. He warns that the assessment tools used in the science of psychology, psychiatry, while they might look objective on the surface, they could actually be based on pre-existing social, ethical, and even legal norms. Hidden assumptions, basically.
So these assessment tools might have built-in biases. They're not as neutral as they seem.
Exactly. That's the concern. And when you combine that potential bias with the increasing use of medications, pharmacological interventions,
Yeah.
the idea that people need to comply, need to take these prescribed medications, can quite easily become a socially acceptable reason, a justification for using coercive measures.
Ah, I see. Compliance becomes the goal.
Right. And from this perspective, you could see forcing medical treatment today as almost a way of reinforcing social boundaries. It sort of echoes Foucault's idea of the great confinement, that historical period when marginalized groups were often shut away, institutionalized.
That's a really powerful parallel. Wow. Okay, now let's talk about legal capacity. Our sources really hammer home how important this is.
It is absolutely fundamental. Legal capacity. It's the recognized autonomy, the right to make your own decisions and act on them. It's a basic human right.
Okay.
And it's enshrined in major human rights documents. The Convention on the Rights of Persons with Disabilities, the CRPD, strongly reaffirms this right for everyone.
And the CRPD was developed, partly at least, in response to that long history where people with disabilities have had their independence, their autonomy undermined through coercive care, right?
Absolutely. That history is exactly why it's so prominent in the CRPD. But despite the CRPD being widely adopted, the reality is that many people with disabilities, particularly those with intellectual and psychosocial disabilities, still have their legal capacity denied.
Even now.
Yes, it often happens under the guise of protecting them, protective measures. But sadly, the result is often exclusion from basic social opportunities, things people without disabilities often just take for granted.
But the CRPD also introduces this concept of supported decision-making, doesn't it, as an alternative?
Yes, exactly. Supported decision-making, along with other supports like making reasonable adjustments or accommodations. It recognizes a crucial point,
Which is?
that it's often social exclusion and barriers in society, not the disability itself, that make it hard for people to be fully included in their communities. These ideas connect really well with theories about relational autonomy, how we're all interconnected and rely on each other when making decisions.
Okay. But it seems there are also some criticisms maybe of the traditional ideas about autonomy itself.
That's right. Traditional views of autonomy often focus very heavily on cognitive abilities, on rationality, and maybe don't give enough weight to the importance of social connections, relationships.
Right.
For example, think about Martha Nussbaum. She includes rationality as a key capability. Now, that's important, but it could unintentionally end up excluding individuals with, say, diminished intellectual ability from having certain claims on state support or resources.
That makes me think about the human rights issues that have been linked to institutionalization over the years. Our sources paint a pretty concerning picture there.
Deeply concerning, yes. The documented human rights violations in places like orphanages, social care homes, psychiatric hospitals, they are truly disturbing.
What kind of things are we talking about?
Well, things like plenary guardianship, where someone else has complete legal control over all your decisions, including medical ones. Forced sterilization, which is just a horrific practice based on eugenics.
Awful.
And even harmful medical experiments, bogus remedies, psychosurgery. And tragically, you have cases like Buck v. Bell, the U.S. Supreme Court, which actually upheld the forced sterilization of people with intellectual disabilities based on those now completely discredited eugenic ideas.
And this isn't just something from the distant past, is it? The UN Committee on the Rights of Persons with Disabilities has expressed concern about things like prenatal screening practices.
Yes, they have. Concerns that these practices can lead to a disproportionately high rate of terminations simply based on a finding of disability.
Wow.
It reflects these deep-seated societal biases and raises really serious ethical questions about how disability is valued. And historically, these kinds of discriminatory attitudes have fueled exclusionary practices too, like the U.S. using disability as a reason to bar people from immigrating.
Okay, shifting gears slightly. Feminist and communitarian perspectives seem to offer a different way of looking at autonomy.
They do. Feminist thinkers, for example, have rightly challenged the traditional emphasis on independence and separation in ideas about autonomy. They point out how this undervalues our connections, our interdependence.
Right.
Lorraine Coe talks about an autonomy obsession in Western thought, and Kenneth Gergen argues that focusing only on the individual, the atom of society, completely neglects the crucial role of relationships and, coordinated efforts.
So how does Article 12 of the CRPD try to sort of weave these different viewpoints together?
Article 12 is really central here. It does two key things. First, it establishes that people with disabilities have equal legal capacity to everyone else. Full stop. Second, it requires countries, states, to create systems of supported decision-making. And these systems must be free from coercion or any kind of undue influence.
And the goal is empowerment.
Exactly. The goal is to empower people with disabilities to have control, to exercise their agency over their lives in all sorts of legal and social situations. Paragraph 4 of Article 12 is really specific here. It says these support systems must respect the person's rights, their own will, and what they prefer.
And I imagine supported decision-making can look quite different depending on the person.
Oh, absolutely. It's not one size fits all. It could involve having personal assistants, maybe peer support networks, an independent advocate like an ombudsman, or just relying on trusted friends and family, whatever helps the person make their own decisions.
Okay.
Ireland, for example, is currently working on putting a pretty comprehensive supported decision-making framework into law, which is a good practical example.
But our sources also seem to point out some limitations with models that are only based on someone's capacity. What's the issue there?
Yeah, some models tend to focus solely on respecting the decisions of people who are deemed to have capacity. But they don't really dig into how those decisions are being made or how support could be provided to help someone make their own decision.
Right, they assume capacity is fixed.
Exactly. They often assume capacity is static, like an on-off switch. And this might not fully align with the, let's say, more expansive vision of Article 12 of the CRPD, which really emphasizes the right to support in making decisions, not just judging capacity.
What about the bigger picture internationally? Are countries interpreting the CRPD differently on this?
Well, since the CRPD was adopted back in 2006, the idea of supported decision-making has largely been embraced, within the disability movement and the legal community. It's generally seen as the preferred model, but different countries have taken slightly different approaches when putting it into practice in their own laws. So, for example, Colombia ratified the CRPD without any reservations, fully accepting all its obligations, including around legal capacity. Canada, on the other hand, included a specific reservation when they ratified. They basically said they reserve the right to continue using substitute decision-making, where someone else makes the decision in what they deem appropriate circumstances. So there's variation.
Let's turn our attention for a moment to the International Covenant on Economic, Social, and Cultural Rights, the ICESCR. How does that fit into the picture of coercive care?
Okay, so the ICECR includes the right to the highest attainable standard of health. That's crucial. And this right includes access to healthcare services and the right to be free from treatment that you haven't consented to. Freedom from non-consensual treatment.
Right. But there's an exception.
There is. Within the framework of the UN Principles for the Protection of Persons with Mental Illness, often called the MI Principles, there's an allowance for coercive treatment specifically in cases of mental illness.
And it sounds like those MI principles are maybe more restrictive than the CRPD in this particular area.
That's generally seen as correct, yes. The MI principles tend to operate on an assumption that mental illness can lead to someone lacking capacity. And they provide for appointing someone else, a personal representative, to make decisions on their behalf.
Without fully exploring support first.
Right. They don't necessarily mandate exploring supported decision-making in the same robust way the CRPD does. So while the MI principles were influential and aimed to protect against unnecessary coercion, they don't quite promote actively supporting someone's own decision-making to the same degree as the CRPD framework.
Our sources also dig into the historical background of legal capacity in Latin America. That sounds really interesting.
It is, yeah. Back in the 19th century, many Latin American countries adopted legal codes, often heavily influenced by the French Code Napoleon.
Okay.
And these codes typically portray the ideal individual as, rational, independent, autonomous. People who didn't fit this mold, including many people with disabilities, were often treated as outsiders with very limited rights.
And this had real, tangible consequences for people with disabilities, I assume.
Huge consequences, absolutely. They were often legally presumed to be absolutely incapable of making their own decisions,
Meaning?
meaning their actions, their contracts, could just be declared legally null and void. Guardians were appointed to make even the most basic life choices for them, things like who they could marry, decisions about children, where they lived.
Wow.
And the law back then even allowed guardians to get permission from the courts for things like sterilization, invasive medical procedures, and institutionalization. The language used in those historical legal documents, say in Colombia, to refer to people with disabilities was often really derogatory, really highlighting the lack of respect and the denial of their basic human dignity.
But it seems legal thinking is evolving, at least in places like Colombia.
Yes, definitely. The Colombian Constitutional Court, for instance, has explicitly recognized that the state has a responsibility to support individuals with disabilities who ask for it. They've emphasized that the state cannot just own someone's will and life choices.
That sounds positive.
It is. But the court's application of these ideas hasn't always been perfectly consistent,
Yeah.
especially when it comes to people with intellectual or psychosocial disabilities.
Mm.
In some of those cases, there's still a tendency towards maybe overprotection based mainly on a medical diagnosis alone, which contrasts a bit with how they approach other types of cases.
What about Canada? Our sources mention that capacity in healthcare decisions is seen as something that can fluctuate, that it isn't fixed.
That's right. Canadian law does recognize that someone's ability to make decisions, their capacity, can vary. It depends on the specific decision being made, the purpose, and also the time. It can change.
Okay.
When it comes to medical treatment specifically, the legal test generally involves assessing whether the person can understand the relevant information and appreciate the consequences of making a particular choice or not making it. However, there's this inherent tension. The law strongly emphasizes individual autonomy in healthcare, but that autonomy is often tied to having legal capacity. You see this in cases like Fleming v. Reed, where the court prioritized the person's wishes expressed previously when they did have capacity.
And there's a risk of misjudgment.
A significant risk, yes, that people with disabilities might be unfairly, inaccurately perceived as lacking capacity simply because of their disability, especially in situations involving involuntary commitment or treatment.
And the Starson v. Swayze case in Canada seems to really bring these complexities to the fore, doesn't it?
It really does. It's a classic example. Mr. Starson had been found not criminally responsible due to a mental disorder. He was refusing proposed antipsychotic medication.
But willing to do other things.
Yes, he was willing to continue with psychotherapy. He challenged the determination that he lacked the capacity to make his own treatment decisions. His argument was that the medications had significant negative side effects, impacting his work and his ability to communicate effectively.
So it really highlights the struggle.
Absolutely. It underscores the immense difficulties in balancing respect for individual autonomy with treatment decisions, especially for those with psychosocial disabilities.
Okay, on maybe a more positive legislative note, the Representation Agreement Act in British Columbia sounds like a concrete step towards embedding supported decision-making in law.
It is a really interesting example, yeah. This act allows adults in BC to formally authorize trusted individuals or even services to assist them with decisions, or even make decisions on their behalf in some cases.
Without the traditional capacity test.
Exactly, without needing to meet the conventional legal definition of capacity to enter the agreement itself. The focus shifts.
To what?
To factors like, can the person communicate their desire for help? Can they demonstrate choices and preferences? Do they show trust in the person they want as their representative? And do they have a basic awareness of what the agreement means and its impact?
That sounds much more nuanced.
It is. And other laws in British Columbia also incorporate similar provisions for assisted or supported decision-making, like the Adult Guardianship Act.
Now, let's turn our attention south to Australia. Our sources mention some systemic challenges in their mental health care system. What sort of issues?
Well, historically, Australia has faced issues like a heavy reliance on family members and unpaid carers to support people with mental illness, and often a service system that reacts to crises rather than providing proactive, ongoing support.
Challenging decisions.
Right. Limited avenues for individuals to effectively challenge involuntary treatment orders. Now, there have been reform movements aimed at reducing discrimination and stigma.
But problems remain.
Yes. Despite reforms, sources suggest there's still differential treatment and discrepancies in services, often linked back to funding limitations. There's also been a lot of critical commentary about how administrative decisions get made and the actual language used in mental health legislation itself.
That sounds familiar. Our sources highlight some interesting decisions by Justice Bell in Victoria, Australia, regarding how laws about treatment should be interpreted. Can you explain his approach?
Yeah, Justice Bell really emphasized that when you're interpreting laws that allow for intrusions on fundamental rights and freedoms like compulsory treatment, you need to be really careful about the principles you apply.
What principles?
Principles like liberal construction, meaning interpreting laws in a way that favors individual rights where possible.
Yeah.
And the principle of legality, which basically says that Parliament must use crystal clear language if it intends to override fundamental rights. You can't just assume it.
Okay.
His approach involves 3 steps. First, identify the rights that are affected. Second, understand the rationale, the reason why the intervention is being proposed. And third, ensure the reasoning is demonstrably justified and proportionate to the situation. It can't be excessive.
This kind of thinking leads us towards the idea of a fusion law, the concept of maybe combining guardianship law and mental health law into one single statute. What's the main argument for doing that?
The core argument is really about discrimination. Having separate mental health laws allows for coercive powers, like involuntary detention and treatment, to be used specifically against people with mental disorders in a way that just doesn't apply to people with purely physical health conditions, even if they lack capacity.
So it treats them differently.
Exactly. The proposed fusion model law, put forward by Dawson and Smuckler, aims to fix this. It suggests integrating the rules about compulsory treatment into the broader legal framework that applies to all individuals who lack capacity and need significant legal protection, regardless of the type of health condition.
Has this been proposed elsewhere?
Yes, Northern Ireland's Bamford Committee also suggested a single law based on capacity that would cover both mental and physical health issues.
But there seems to be some debate about whether the CRPD actually prohibits having separate mental health laws altogether. Is that right?
Yes, that's a point of contention. Some commentators argue strongly that Article 14 of the CRPD, which deals with liberty and security of person, effectively means separate mental health laws are discriminatory and not permissible.
But not everyone agrees.
No. Others, like Neil Rees, argue that treating mental and physical health differently in law can sometimes be legally justified, maybe as a necessary special measure to address specific needs or risks associated with certain mental health conditions.
So the fundamental question remains.
Exactly. What is the justification, if any, for having laws that can lead to depriving someone of their liberty because of a mental illness, but not necessarily for a comparable situation involving a physical illness? That's the crux of the debate.
And the issue of discrimination and stigma in mental health law is obviously a huge part of this.
Oh, absolutely huge. Laws that are discriminatory or perceived as discriminatory definitely contribute to the pervasive stigma that people with mental illness experience.
And the impact of that stigma.
It's profound. Reports like the U.S. President's new Freedom Commission on Mental Health back in 2003 identified stigma as a massive barrier. It leads to fear, rejection, people avoiding those with mental illness, and outright discrimination.
And for the individuals themselves.
It can lead to low self-esteem, isolation, hopelessness. And critically, it can deter people from seeking help in the first place for fear of being labeled or treated badly.
We also heard from service users.
Yes, service users and their carers have reported feeling utterly powerless, even terrified and traumatized by the experience of being detained under mental health laws. Mine, the UK mental health charity, provided similar evidence highlighting how forced medication can undermine good therapeutic relationships and patients' autonomy.
But there seems to have been a definite shift towards more rights-based, recovery-focused approaches in mental health practice in recent years, hasn't there? At least in some places.
Yes, absolutely. In the UK, for instance, community mental health practice has increasingly moved towards crisis services, psychological treatments, and approaches that are explicitly based on human rights, values-driven practice, anti-stigma efforts, and the recovery model.
And the recovery model is about?
It's about empowering service users, putting them at the center of their own journey to recovery, however they define recovery. It's not just about symptom reduction.
Could these newer approaches reduce the need for compulsion?
That's the hope and the big question. Could they reduce the need for compulsory powers? It's certainly debated. And it's interesting to note estimates suggesting that a significant chunk, maybe even a majority, of patients currently detained under the Mental Health Act in England actually have the capacity to make their own decisions.
Which suggests
that a law based more squarely on capacity and best interests could potentially limit the use of compulsory treatment and encourage more genuinely patient-centered practices.
How might a law like that affect the use of community treatment orders, or CTOs, which we talked about briefly?
It could have a really significant impact, particularly in places like England, where they're used quite a bit.
How so?
Well, think about it. If someone subject to a CTO is assessed as having the capacity to manage their own medication and make decisions about their care in the community, then the justification for keeping the CTO in place becomes much weaker, doesn't it?
Right.
Currently, psychiatrists often face this dilemma with CTOs. If the patient's health improves, is the CTO still legally necessary? But if it doesn't improve, does that automatically mean the CTO must continue? A capacity test could offer a clearer, more natural point to end a CTO.
Okay. Now, making sure there are proper safeguards against detaining people unfairly, arbitrarily, is obviously critical, especially for those who might lack the capacity to make decisions about where they live.
Absolutely crucial. And the infamous Bournemouth gap in the UK's 1983 Mental Health Act really threw this issue into sharp relief.
Remind us about Bournemouth.
It concerned a man, HL, who had profound learning disabilities. He was being accommodated, essentially kept, in a hospital informally. There was no formal legal detention process. Because he was compliant, he didn't actively resist.
Even though he couldn't consent.
Exactly. Even though he lacked the capacity to consent to being there, and, crucially, he wasn't allowed visitors, he couldn't leave. Lord Stein, in the House of Lords judgment, famously called this situation an indefensible gap in the law.
And there have been legal developments since then to try and close that Bournemouth gap, right, for people in hospitals and care homes.
Yes, thankfully. Subsequent court decisions, different interpretations of the 1983 Act, and importantly, the introduction of the Mental Capacity Act in 2005, MCA, aimed to address this gap, at least for people in hospital settings initially.
How did they do that?
Cases like a primary care trust and PVAH and a local authority allowed courts to make declarations that someone's detention was lawful under the Mental Capacity Act, but with safeguards built in, like advanced declarations about wishes and regular reviews.
And at the European level?
The Stana v. Bulgaria case at the European Court of Human Rights further hammered home the point. It confirmed that even guardianship arrangements, if they involve significant control over a person's life and movement, need proper legal procedures that comply with human rights standards, specifically Article 5 on liberty. Not all guardianship is detention, but it can be.
It sounds like the existing guardianship system under the UK's 1983 Act might actually have offered a less complicated way to deal with the issues that led to the deprivation of liberty safeguards or DOLs being created. Is that a fair assessment?
Some commentators argue exactly that, yes. Guardianship under the 1983 Act allows for specific decisions to be made, like where someone lives. Financial and social welfare matters, if the person lacks capacity for those, are handled separately under the Mental Capacity Act.
Those more targeted.
Potentially, yes. And the Stana v. Bulgaria case clarified that guardianship can amount to detention if the level of control over the person's movement is high enough. So, arguably, the tools were there, perhaps less complex than DOLs. The key issue is ensuring adequate safeguards, whatever the system.
Let's consider how this idea of best interests, a term we hear a lot, is actually applied in specific healthcare settings. Our sources discuss a study about feeding decisions for stroke patients.
Yes, this was a UK study looking at how decisions about feeding, particularly artificial nutrition and hydration, were made for stroke patients before the Mental Capacity Act 2005 came into full effect.
And what did they find?
They found clinicians frequently use the concept of best interests to explain why their practices varied so much from case to case. Now, it's really important here to remember the distinction. The Mental Capacity Act only applies if the person lacks the capacity to make that specific decision at that time. The Mental Health Act is separate.
Right.
Historically, before the MCA, decisions for incapacitated adults were often based on the common law doctrine of necessity, or the court's parent's patria jurisdiction, the state acting as a protective parent. The MCA and then DOLs, which specifically addressed the Bournemouth gap for non-objecting incapacitated people in hospital care homes, largely replaced that.
So common law isn't enough anymore.
No. Common law can no longer be used as the sole basis to deprive someone who lacks capacity of their liberty in a hospital or care home. You generally have to use the MCA, DOLs, or potentially the Mental Health Act framework.
But applying this concept of best interests seems really challenging, especially in those early acute stages of a stroke when things are changing rapidly.
It certainly can be, yes. The study found that in the immediate aftermath of a stroke, the top priority often became sustaining life and improving the medical prognosis. And sometimes, assessing the patient's actual capacity to make decisions about feeding got pushed down the list or wasn't done thoroughly.
And opinions differed.
Hugely. There was a really wide divergence of views among the clinicians in the study about how or even whether to assess capacity for decisions about nutritional interventions. And remember, the Mental Capacity Act explicitly states that making an unwise decision doesn't in itself prove lack of capacity.
But clinicians sometimes question capacity based on the decision itself.
Yes, that happened in the study. For instance, if a patient with swallowing difficulty still desired a normal meal, some clinicians questioned their capacity based on that choice, seeing it as too risky. This highlights a potential conflict. Clinical teams might argue against a patient's choice based on their view of the patient's best interests, while nursing staff might also have concerns, perhaps related to perceived risks to themselves in facilitating that choice.
And the very definition of what counts as life-sustaining treatment seems to add another layer of complexity here.
It absolutely does. The MCA's Code of Practice clarifies that whether a specific treatment is life-sustaining really depends on the individual circumstances of the case. It's not always clear-cut.
Especially with feeding.
Exactly. There are complex ethical debates and genuinely divided opinions on whether artificial nutrition and hydration, ANH, should always be viewed as basic care, or sometimes as a medical treatment that can be withheld or withdrawn, especially for stroke patients whose level of consciousness might fluctuate. Applying legal precedents from cases involving people in persistent vegetative states, PVS, or minimally conscious states, MCS, to the more dynamic situation of stroke recovery is also uncertain.
So what were some of the key ways the clinicians in that stroke feeding study actually thought about best interests? How did they arrive at those decisions?
Well, best interests was definitely the phrase they used most often to frame their decisions. A key factor that often came up before even considering the potential benefits of feeding was the principle of not doing harm, primum non nocere.
Okay.
Clinicians also stressed the importance of involving family members in discussions. However, the study suggested that family views were generally only supported if they broadly aligned with the clinician's own assessment of the situation.
So family input wasn't decisive.
Not necessarily on its own, no. And interestingly, some clinicians also mentioned being aware of their role as public sector employees. They expressed concerns about prolonging life that they considered futile, partly in light of limited healthcare resources and financial constraints.
Right, the resource question. Okay, let's take a closer look now at community treatment orders, CTOs, specifically in England and Wales. Can you lay out the specific conditions needed to impose one?
Sure. In England and Wales, for a CTO to be put in place, several criteria must be met. First, the person must have a mental disorder of a nature or degree that requires medical treatment.
Okay.
Second, it must be necessary for their health or safety or for the protection of other people that they receive that treatment. Third, the treatment can be provided without them having to stay in hospital.
So community treatment is viable.
Yes. Fourth, it have to be necessary for the patient's health or safety or the protection of others that they remain liable to be recalled to hospital for treatment if needed. Fifth, appropriate medical treatment must actually be available for them in the community. And crucially, the patient's agreement isn't required.
No agreement needed, and they can be recalled.
Yes. The order includes the power for the responsible clinician to recall the person to hospital if, for example, they stop taking their medication and their condition deteriorates, or they pose a risk.
And how long do these orders typically last? How are they reviewed?
The initial CTO lasts for up to 6 months. It can then be extended for a further 6 months, and after that, it can be renewed for periods of 1 year at a time.
And the renewal isn't automatic.
No, definitely not. The criteria for renewal are similar to the initial criteria. It requires the agreement of both the responsible clinician and an approved mental health practitioner, AMHP. They also usually need an opinion from an independent doctor who has examined the patient, and a written statement from the AMHP confirming the criteria are met. This all gets reported to the hospital managers. And the patient has the right to apply to the first-tier tribunal, the mental health tribunal, to have the CTO reviewed and potentially discharged.
Now, while these CTOs aim to provide a legal framework for care in the community, our sources mention limitations, particularly around forcing treatment while someone is actually in the community.
That's a key point, yes. A CTO in England and Wales does not give clinicians the power to forcibly treat someone in the community against their will, if they have capacity to refuse at that moment. The power is recalled to hospital, where treatment can then be given under the original detention section if necessary.
But CPOs do offer some benefits.
Potentially, yes. They offer a more structured and legally transparent framework for managing care in the community, compared to, say, previous arrangements like supervised discharge or just informal follow-up. This structure can lead to greater continuity of service, better access to care, more regular contact with carers and professionals. And advocates argue this can positively influence the patient's experience and stability.
So it's a step towards deinstitutionalization.
You could see it that way, yes.
Yeah.
The introduction of CTOs represents perhaps a cautious step away from relying solely on the institution, the hospital, as the bedrock of psychiatric care. But, and this is a big but, this shift raises those difficult ethical questions if the CTO framework operates by essentially accepting, or being perceived as accepting, a certain level of deprivation of basic human rights or autonomy in the community.
There's also a difference in the legal test compared to leave of absence from hospital.
Yes. For extended leave of absence under the Mental Health Act, Section 17 leave, the person generally still needs to be considered liable to detention in hospital. The CTO framework shifted this slightly. The key is demonstrating that safe treatment in the community is possible, coupled with that power to recall if needed. It's a subtle but important difference in focus.
Okay. Moving from the idea of coercion, perhaps, towards coordination, our sources touch on the significant challenges of supporting individuals who have multiple coexisting conditions, like mental health disorders alongside substance abuse or brain injuries or intellectual disabilities.
Yes, this is a huge issue in practice. People with these complex coexisting needs often fall through the cracks between different service systems. Mental health services might say the primary issue is substance use. Substance use services might point to the mental health condition. Disability services might not feel equipped. You get a lot of fragmentation and buck passing.
And the legal focus is often narrow.
Often, yes. Many of the laws in this area tend to focus primarily on the criteria for involuntary detention and treatment within one specific system, rather than facilitating coordination between systems.
So could legally sanctioned coordination be helpful?
Well, that's the debate. What are the potential advantages and disadvantages of having legal frameworks that actually mandate or facilitate the coordination of services to provide more holistic, individualized care for these complex cases? It's tricky, especially given the often unclear overlap between guardianship laws and mental health laws for substitute decision-making in different jurisdictions.
Australia, I believe, has some specific laws dealing separately with alcohol and drug dependency.
That's right. Some Australian states have distinct legislation that enables the involuntary detention and treatment of individuals who are severely dependent on alcohol and other drugs people historically referred to rather bluntly as inebriates.
What are the criteria for that?
Taking the New South Wales Drug and Alcohol Treatment Act of 2007 as an example, Section 9 allows a magistrate to order involuntary detention and treatment if certain conditions are met. These include showing the person has severe substance dependence, that the detention is necessary for their protection from serious harm, that they're likely to benefit from treatment but have refused it, and critically, that there are no less restrictive means available to ensure they get treatment.
But is this approach effective?
That's highly debatable. The effectiveness of compelling someone into short-term intensive treatment for addiction in terms of achieving long-term behavioral change is questionable. One Australian study cited suggests it might not be that effective. And importantly, there hasn't really been a full evaluation of the long-term outcomes for people who are detained under these specific drug and alcohol treatment laws.
Are there examples, then, of legal frameworks that specifically aim to coordinate services for people with these complex coexisting needs rather than just compel treatment for one issue?
Yes, there are models out there. Assertive community treatment, ACT teams, for example, often involve multidisciplinary professionals working together in a coordinated way, though their legal basis varies.
Any specific legislative examples?
The Multiple and Complex Needs Initiative, or MCNI in Victoria, Australia, is a specific example cited. This involved creating a panel to develop individualized care plans, bringing different services together. Crucially, it was supposed to operate with the person's consent.
Consent in these situations must be complex, though.
Extremely complex.
Yeah.
Especially if the person has a history of involuntary detention, or if the alternative they're facing is potentially prison. How voluntary is consent in that context? Evaluations of the MCNI showed some potential benefits, like improved access to services and maybe fewer crisis events for the individuals involved. But there were also significant concerns about the program's financial sustainability due to the high costs involved in providing that intensive coordinated support. These cost challenges echo those seen with other intensive programs for high-risk individuals, like the Dangerous People with Severe Personality Disorders, DSPD units, that used to operate in England. It's expensive to do well.
Okay. Our sources introduce a couple of powerful concepts, sanism and pretextuality, in the context of mental disability law. Can you explain what those terms mean?
Sure. Sadism is essentially irrational prejudice against people perceived to have mental illness. It's analogous to racism or sexism, but focused on mental health status. It involves stereotypes, fear, and discrimination based on assumptions about mental illness.
And pretextuality.
Pretextuality refers to the reliance on reasons that aren't the real reasons for a decision or action, using false or misleading justifications, basically, covering the actual motive with a more acceptable sounding one.
And the argument is these are pervasive.
Yes. The argument presented in our sources is that both sanism and pretextuality are deeply embedded, almost unconsciously sometimes, in all aspects of mental disability law. That they contaminate not just legal practice and judicial decisions, but even scholarly discussions, and ultimately prevent a truly clear-eyed understanding of the field and the experiences of the people affected.
Wow. In stark contrast to those challenges, the CRPD, the Convention on the Rights of Persons with Disabilities, is presented as a really significant, almost revolutionary positive development.
It absolutely is. The CRPD is truly a groundbreaking international human rights treaty for people with disabilities. Its core message is equality, promoting equality in almost every aspect of life.
And its view of disability.
Crucially, it firmly endorses the social model of disability. It says that disability arises from the interaction between a person's impairment and the barriers attitudinal, environmental, institutional present in society. This is the fundamental rejection of the traditional medical model, which sees disability solely as an individual deficit, a model that has heavily influenced mental disability law for a long time.
So the CRPD provides a new framework.
Exactly. It provides a comprehensive framework for ensuring that mental health laws, and indeed all laws, fully recognize and respect the rights of people with mental illness and other disabilities.
What are some of the key features or specific articles of the CRPD that are particularly important in this context?
Well, the CRPD's uniqueness lies in it being the first legally binding international agreement dedicated to the comprehensive protection of disability rights. It doesn't just prohibit discrimination, it actively requires states to take positive steps to create an enabling environment where genuine equality can actually be achieved.
Any specific articles?
Article 12 on equal recognition before the law and legal capacity is absolutely central, as we discussed. Article 13, guaranteeing access to justice, is also critical. And the importance of the right to adequate and dedicated legal counsel in mental disability law proceedings flows directly from these principles. States have an obligation under Article 12 to provide access to the support people may need to exercise their legal capacity.
The idea of human dignity also seems to be playing a much bigger role in how human rights law is interpreted generally.
Yes, definitely. Christopher McCrudden's analysis, mentioned in our sources, highlights this increasing reliance on the concept of human dignity in human rights jurisprudence worldwide.
But it's not always clearly defined.
That's McCrudden's point. Human dignity often lacks a single, detailed, universally agreed-upon interpretation. However, despite that ambiguity, it serves important functions. It provides a language, a justification for judicial decisions about how much weight to give different rights, how to apply international laws domestically, domestication, how to consider the specific context of a case, and sometimes even how to generate or recognize new rights based on this fundamental value.
This brings us quite naturally to mental health courts and how they might relate to dignity and human rights.
It does. And it's important context here that, despite the legal focus on dignity, violations of basic human rights for detained individuals are still widespread globally. Article 10 of the International Covenant on Civil and Political Rights guarantees humane treatment for all persons deprived of their liberty.
But reality falls short.
Often, yes. Michael Perlin's research, cited in the sources, has documented frankly abysmal conditions in many forensic mental health facilities, sometimes even worse than in general civil psychiatric hospitals. He points to particularly concerning practices observed in places like Hungary and Albania in his work.
And attitudes matter.
Hugely. Perlin argues that when defendants with mental disabilities are viewed through a lens of having a defect of morality or will, rather than a health condition requiring support, it fosters a culture of punishment within the criminal justice system. And this culture acts as a major barrier to meaningful reform and truly therapeutic approaches.
So against that backdrop, what exactly are mental health courts or MHCs, and what are they trying to achieve?
Okay, so MHCs are specialized court dockets or sometimes separate courts, designed specifically to deal more holistically with individuals who've been arrested, usually for nonviolent misdemeanor offenses, where it appears that a mental illness was a significant precipitating factor in the alleged offense.
And the goal is diversion.
Primarily, yes. The aim of the MHC judge and team is typically to divert these individuals away from the traditional criminal court process and potential incarceration. In exchange, the person agrees to participate in community-based mental health treatment and adhere to a supervision plan. The ultimate hope is to address the underlying issues and reduce the likelihood of future criminal justice involvement.
It sounds like a team effort.
It absolutely is. MHCs typically use a team-based approach. This involves the judge working collaboratively with representatives from various justice system agencies, like prosecution, defense counsel, probation, and crucially, mental health treatment providers. They work together on screening potential participants, developing individualized treatment plans, supervising progress, and monitoring compliance.
Now, there's a potential criticism, isn't there, that MHCs might inadvertently create a kind of second-class citizenship for people with mental disabilities within the justice system. How is that concern addressed?
That's a really important concern, and it's definitely raised. However, the counter-argument put forward by proponents of MHCs is that they actually decrease the likelihood of these individuals being treated poorly or inappropriately within the traditional criminal justice system, which often lacks the expertise or resources to respond effectively to mental health needs.
So they might offer better treatment?
Potentially, yes.
Yeah.
Research by Liu, for example, suggests that sanist biases might actually be reduced by judges and MHCs who are specifically trained and sensitive to these issues. Weller observed how, in regular courts, a patient's attempts to discuss their care might be wrongly labeled as non-compliance, whereas thoughtful MHC judges are more likely to encourage dialogue and try to understand the person's perspective.
And participants feel less coerced?
Some studies indicate that yes. One study mentioned found lower levels of self-reported coercion among participants in a specific MHC compared to traditional court processing. Proponents argue this approach aligns well with Article 3A of the CRPD, which calls for respect for inherent dignity. Kay asserts that MHCs divert people from jail to treatment, help reconnect them with support systems, and can ultimately help restore their sense of human dignity.
But there are also critiques beyond the second-class citizen argument, right? Like the idea that MHCs might offer false hope or depend too much on the personality of the judge.
Yes, those critiques exist too. The false hope argument often stems from the reality that community mental health service systems are frequently under-resourced, fragmented, or simply unavailable in many areas. So the MHC might promise treatment that doesn't actually materialize adequately.
But is that the fault of the MHC model itself?
Supporters would argue no. They'd say the deficiency lies with the broader systemic issues in mental health service provision, not with the MHC concept itself. The MHC is trying to work within and sometimes overcome those limitations.
And the reliance on charismatic judges.
That's another concern, that the success of an MHC might be overly dependent on the specific presiding judge's charisma, commitment, and approach. Judge Ginger Lerner Wren in Broward County, Florida, is often cited as a pioneering and particularly effective example.
But are other MHCs successful?
Yes. While Judge Lerner Wren is renowned, proponents point out that many other MHCs also manage to treat litigants with dignity and respect, often contrasting favorably with the sometimes harsh or uncomprehending treatment individuals with mental disabilities can face in non-specialized courts.
So the solution isn't necessarily to ditch MHCs.
The argument is no. The solution isn't to eliminate MHCs, but rather to focus on improving them. This means focusing on judicial attitudes, implementing mandatory training for judges and all court personnel involved, and actively working to replicate the successful models and best practices across different jurisdictions.
Ensuring that defendants actually receive adequate legal representation within MHCs is also a really critical piece, isn't it?
Absolutely essential. Concerns have definitely been raised about whether defendants in MHCs consistently receive the quality and type of legal representation they need and are constitutionally entitled to.
What are the specific concerns?
Carney, for instance, characterized the assumption that counsel is always adequate as another form of false hope. Key issues highlighted include the potential for defense counsel, sometimes unintentionally, to contribute to coercion, pressure on clients to plead guilty quickly to enter the MHC program without fully exploring all options, and often a lack of specialized knowledge among defense lawyers regarding mental health issues, treatment options, and the complexities of the MHC process itself.
What are some potential solutions to strengthen the role of defense counsel?
Solutions often draw from the principles of therapeutic jurisprudence, TJ, which, as we mentioned, looks at the law's impact on emotional life and psychological well-being, such as ensuring lawyers adequately counsel their clients on both the potential benefits and the potential drawbacks or risks of participating in an MHC. Making sure judges and counsel actively work together to ensure the defendant's dignity is respected and they have a meaningful voice in the proceedings. Incorporating specific training on MHCs into clinical legal education programs for law students.
And specialized knowledge for lawyers.
Crucial. Defense counsel really need a background in mental health issues and ideally training in crisis communication skills. The ideal scenario is for all personnel involved in the MHC, judge, prosecutor, defense, treatment providers, probation, to have some level of mental health training and good knowledge of the available community resources.
So well-run MHCs can be positive.
The conclusion often drawn is that well-structured MHCs, particularly those with judges who actively embrace the TJ model, can exemplify the practical utility of therapeutic jurisprudence. They can give litigants that voice and respect that TJ demands, potentially leading to better outcomes than the traditional adversarial system for this specific population.
Okay. Let's shift focus again, this time to New Zealand, and how they manage offenders with intellectual disabilities. It sounds like they had a unique legislative journey.
They did. New Zealand initially made a conscious decision to try and exclude intellectually disabled offenders from the scope of their main Mental Health Act. The intention was good to avoid these individuals being improperly detained long-term in psychiatric institutions that might not be suited to their needs.
But there was an unintended consequence.
Yes, there was. This exclusion meant that some individuals with intellectual disabilities who also had coexisting behavioral issues and who might previously have been managed under the Mental Health Act were instead discharged into the community, often without adequate supervision or support. Sadly, some of these individuals went on to commit serious offenses.
And the government responded.
Yes. This led to significant public concern and a government response, culminating in the development of the Intellectual Disability Compulsory Care Bill. This eventually became the Intellectual Disability Compulsory Care and Rehabilitation Act, often referred to as the IDCCRA, which focused specifically on offenders with intellectual disabilities.
And how is the concept of care actually defined under this act, the IDCCRA? It seems central.
It is central, but the definition is surprisingly minimal. In practice, care under the IDCCRA has largely come to mean containment and management within a designated care facility until the compulsory care order ends.
Not much more than containment.
The Act does state that this care must be administered with respect for the individual's cultural identity and beliefs. But in terms of the actual nature and delivery of the care, the legal definition itself is quite sparse.
Which contrasts with broader ideas of care.
Significantly. You have thinkers like Patterson emphasizing that medicine requires humanity alongside technical skill, quoting Peabody's famous line that the secret of the care of the patient is in caring for the patient. Or Toronto's broader view of caring as encompassing everything we do to maintain and repair our world, stressing interdependence. Or Barnes and Branley noting that care acknowledges bodily, spiritual, material aspects, the perspectives of givers and receivers, power dynamics, and moral dimensions. The IDCCRA definition seems much narrower.
The fact that detention under the IDCCRA can potentially be indefinite has led to legal challenges, hasn't it? Particularly concerning the liberty of the people subject to these orders.
Yes, that's been a major point of legal contention. Courts have had to consider whether the potentially open-ended nature of this compulsory count affects how care recipients perceive the fairness of the system. Does it feel like punishment? Is it discriminatory compared to how other offenders might be treated?
And proportionality.
Exactly. The Court of Appeal has had to weigh the principle of proportionality. Is the continued deprivation of liberty proportionate to the ongoing risk? And has acknowledged that its decisions on these matters could have really significant far-reaching impacts.
What about the specific rights that are included in the IDCCRA, and how does the inherent coercion of the system fit with those rights?
Okay, so the IDCCRA does include a list of rights, many modeled on those in the main Mental Health Act. These include things like the right to have your culture respected, the right to medical treatment, the right to seek independent advice, and the right to legal advice.
But there's a difference in review.
Yes, a key difference is that care recipients under the IDCCRA don't have the same access to a formal review tribunal as patients under the Mental Health Act do. and coercion is absolutely integrated into the system. Care recipients are legally required to accept care that is properly given under their court order or care plan, and they must comply with lawful directions from staff.
Which could be hard to assess.
Exactly. Assessing whether care is properly given or a direction is lawful can be incredibly difficult for anyone, let alone someone with an intellectual disability, navigating this complex system.
New Zealand courts have also had to grapple with the concept of static risk when deciding whether to extend these compulsory care orders, CCOs. What does that involve?
Static risk refers to risk factors that are generally considered unchangeable things, like a person's past offending history. The question courts faced was, are these static risk factors, on their own, sufficient grounds to keep renewing a CCO, potentially indefinitely, regardless of how long the person has already been subject to compulsory care?
What was the argument?
In the VMVR-ACA central case cited, the Attorney General argued that yes, the continued presence of risk alone was sufficient for renewal, irrespective of the time already served under the order.
And the counterargument?
The counterargument, which the court seemed to lean towards, was that the principle of proportionality demands more. The longer the period someone has already spent under compulsory care, the greater the current risk of harm they pose must be to justify continuing the deprivation of their liberty. It requires balancing their health and safety needs against their fundamental right to liberty.
And other factors.
The court also noted the principle that detention must always be for the shortest time necessary. And while the seriousness of the original index offense isn't a direct measure of current risk, it is still considered a relevant background factor in the overall assessment.
And what role does the prospect of rehabilitation actually play in the IDCCRA framework? The title includes rehabilitation.
It does, but it's perhaps slightly misleading. The Act clarifies that the prospect, or lack thereof, of rehabilitation is not the sole determining factor when deciding whether to issue a CCO for someone, say, an inmate with an intellectual disability who is already on preventive detention.
So a lack of rehabilitation prospects doesn't stop a CCO?
Correct. Similarly, the absence of clear rehabilitation prospects doesn't automatically prevent a CCO from being issued or renewed. While community safety is stated as a primary guiding principle, even that doesn't necessarily preclude transferring someone considered unsafe from the prison system to the IDCCRA regime. The focus seems to be more on managing the perceived risk within the IDCCRA system, rather than avoiding the risk altogether.
There's also been a more recent focus on protecting the broader human rights of intellectually disabled offenders within the New Zealand legal system, hasn't there? Beyond just the IDCCRA itself.
Yes, recent legal attention has turned to alleged breaches of broader human rights instruments concerning this group. This includes scrutiny around the right to a fair and public hearing by an independent and impartial tribunal. Is the current system meeting that standard?
And wider context.
There's also Hewitt's reminder, mentioned in the sources, that the very concept of normality can sometimes be used, perhaps subtly, to deprive individuals who don't fit the mold of protections they should be entitled to. And cases like Brown v. Plata from the U.S. Supreme Court serve as important reminders of the state's fundamental obligation to provide appropriate medical care for all incarcerated individuals, and the recognition that incarceration itself is often inherently unhealthy.
Okay, let's shift our focus one final time to the incredibly complex issue of brain injuries and their relationship with coercive care. This seems like another really challenging area.
It absolutely is. Brain injuries, whether acquired through accident or illness, or developmental like fetal alcohol spectrum disorder, FASD, can have such a wide range of effects. They can impact personality, impulse control, judgment, memory, concentration, mood, problem-solving skills, sometimes leading to what's known as dysexecutive syndrome.
And this obviously creates significant challenges when these individuals come into contact with the legal system, particularly around assessing their fitness to stand trial.
Yes. Individuals with significant brain injuries may be found unfit to stand trial because they can't understand the proceedings or participate in their defense. The tragic potential consequence is that they can end up being detained for very long periods, sometimes indefinitely, without ever actually being found guilty of an offense.
And where are they detained?
That's a critical issue. Sometimes this detention occurs in prison environments, simply because there are no other suitable, secure facilities available. This raises profound human rights concerns, especially if those prison settings are medically inappropriate for the person's needs. It could potentially constitute cruel, inhuman, or degrading treatment, contrary to the CRPD.
This is a particular issue for some groups.
Yes. It's highlighted as a particular concern for Indigenous persons, for example, in Australia's Northern Territory, due to a documented lack of suitable therapeutic secure facilities. And beyond the fitness to stand trial issue, it's important to remember that many individuals with brain injuries end up being informally institutionalized, placed in facilities without the proper legal rights and procedural safeguards they would have under formal civil commitment laws. This brings us back full circle, in a way, to the Bournewood problem, that situation where people lacking capacity were detained without formal processes because they were compliant.
Exactly. The lack of formal assessment, clear legal status, and regular independent reviews can leave individuals with brain injuries who lack capacity but don't resist placement in a similarly vulnerable, legally precarious position.
Brain injury also adds immense complexity when it comes to determining criminal responsibility itself, doesn't it?
Right.
Assessing intent, understanding consequences. Absolutely.
Yeah.
The sources give several case examples, often involving individuals with FASD, that illustrate these difficulties. How do you fairly assess criminal responsibility and intent when someone's cognitive functions, impulse control, and understanding of consequences are significantly impaired by a brain injury?
Cases like R.V. Doolin.
Yes, the R.V. Doolin case involved an Indigenous defendant with FASD who was found unfit to stand trial but was placed under a custodial supervision order in prison due to the lack of alternative facilities. The DPP Moore case showed the difficulty courts sometimes have in clearly correlating the effects of FASD with the specific offending behavior, even with expert evidence.
And the risk assessment challenge.
That's highlighted by the case of Jacob Comey, who was released after an offense linked to a brain injury and subsequently faced much more serious charges. It underscores the challenges in accurately assessing future risk. It's also noted that Indigenous persons are often overrepresented in these cases, and cultural factors need careful consideration. Coexisting psychiatric and developmental disorders are also very common in individuals with brain injuries interacting with the criminal justice system.
And the lack of facilities remains key.
It's a recurring theme. The lack of suitable, secure therapeutic facilities frequently leads to brain-injured individuals being detained in penal settings, which, as we've said, potentially contravenes human rights obligations and continues to prompt lobbying for law reform and investment in appropriate services.
When it comes to sentencing offenders who are found criminally responsible but have a brain injury, what kinds of factors do Australian courts typically take into account?
Australian courts will generally consider several factors. These include the nature and severity of the brain injury's symptoms, the degree to which the injury impacted the person's mental capacity at the time of the offense and also at the time of sentencing, and critically, the causal relationship, if any, between the brain injury and the offending behavior itself.
Can it reduce the sentence?
Yes, a brain injury can be a significant mitigating factor, potentially leading to a reduced sentence. However, courts emphasize it's not a license to offend. They typically require clear expert evidence that directly links the impairment caused by the injury to the commission of the crime, or demonstrates why a standard custodial sentence would impose an exceptional hardship on that particular individual due to their injury.
So it's not automatic mitigation.
No, definitely not. Courts are not always receptive to arguments that simply having a brain injury automatically reduces moral culpability or makes imprisonment significantly harsher, without specific evidence connecting the injury to the offense or the experience of punishment.
Finally, let's quickly revisit the HLV-UK case, the Bournewood case we mentioned earlier. It seems particularly relevant to this core issue of when someone is actually considered to be deprived of their liberty, even if it's done with good intentions.
Absolutely. Just to recap, HLV-UK involved HL, the man with profound learning disabilities who was informally detained in a hospital because he was compliant. The European Court of Human Rights, ECTHR, made several key findings.
What were they?
First, they found that HL's situation did constitute a deprivation of liberty, even though the stated aim was care and treatment, and even though he didn't resist. Second, they accepted that his condition was of a nature warranting compulsory confinement under Article 5 of the European Convention.
But the process was flawed.
Critically, yes. The ECTHR concluded that the lack of procedural safeguards, the absence of any formal admission process or means for review, failed to protect HL against arbitrary deprivation of liberty. This breached Article 5.1 because there was no proper legal procedure, and also Article 5.4 because HL had no way to speedily challenge the lawfulness of his detention before a court.
And they introduced a specific test.
Yes, this is where the ECTHR used the relative normality test to help determine if a deprivation of liberty had occurred. This involves considering the specific capabilities of the individual concerned and comparing their concrete situation to the ordinary life that might be expected for a comparable adult without that disability. It's about the degree of confinement relative to what would be normal for them, considering their circumstances, but not defined solely by their disability.
So as we've really unpacked in this deep dive, the whole issue of coercive care is incredibly complex, isn't it? It touches on everything from, historical practices in mental health right through to cutting-edge debates in contemporary human rights law.
It really does. We've seen this constant, often uncomfortable tension. On one hand, the desire, often genuine, to protect individuals deemed vulnerable. And on the other hand, the absolute fundamental importance of respecting their autonomy, their dignity, and their right to make their own informed decisions about their lives and bodies.
Yeah. We've navigated through the real intricacies of trying to apply legal capacity frameworks fairly across different legal systems, especially for people with diverse disabilities. We've touched on the profound ethical challenges surrounding institutionalization and when, if ever, it's appropriate for someone else to make decisions on your behalf.
And those ongoing debates about how the law itself should be used not just to compel treatment, but perhaps more constructively, to facilitate support, coordination, and genuine inclusion. It's clear that finding the right balance here is, well, it's an ongoing struggle, and there are no easy answers.
This deep dive has really aimed to give you, the listener, a thorough understanding of these multifaceted issues, drawing from lots of different legal and ethical viewpoints presented in our source materials.
Hopefully providing that comprehensive overview we aimed for at the start.
Absolutely. And that brings us to maybe a final point for you to mull over. Given this inherent tension we've discussed between protection and autonomy, how can societies realistically develop systems of care and support for people with disabilities and mental health conditions that are truly rights-respecting but also genuinely effective and safe?
That's the million-dollar question.
It really is. What role can our evolving legal frameworks like the CRPD and maybe just a deeper, more empathetic understanding of individual experiences and preferences play in actually achieving that crucial, delicate balance?
Something to keep thinking about, definitely.
We really encourage you to continue exploring the resources related to these topics and to reflect on the implications of coercive care in all its forms in the various contexts where it arises. Thanks for joining us on The Deep Dive.